For me, these are the people that are so invested into this industry, which this is all I know. I've been a realtor for 25 years, and anybody that's pouring their life, their heart and soul into this industry, they're my people.
Delaware is a very small state. We only have about 4,200 realtors in the entire state. You don't have the opportunity to meet or talk to many of the other realtors if you don't have a transaction with them. So this is a great way to meet new people.
The business is very transactional, but it also depends on what the market's doing. So you always want to be sure that you're learning and keeping ahead with all the trends.
You never know too much. When you think you do know too much, then you've already begun your slide to mediocrity. We're in the people business. Being with people on a day-to-day basis and getting to see them outside of Zoom and Google Meet is a great opportunity.
So are we ready? Are we ready to announce the 2023 Realtor of the Year? Can we get a drum roll? The 2023 Realtor of the Year for the Delaware Association of Realtors is Dr. Susan Giove.
I thank all of you for your love and affection and your encouragement. I'm deeply honored.
Even though we're competitors, by trade, it does feel like a community. Like we take care of each other, we help each other.
Well, I think you should come to this event, whether you're a new agent or a seasoned agent, because it does give you a chance to network.
The networking, the expo, and then obviously the classes. But once everybody got here and we started moving and talking and shaking, the whole environment, the energy got warm because we're all in here, we're making memories, we're talking, and it just creates a different energy than online. DAR, we're an incredible organization. Love the community, love the realtors, and we just love the real estate industry in Delaware.
Good afternoon, everyone. Thank you for joining us for our special meeting this afternoon, the DAR Lay of the Land, and we're going to share some updates with you, a few announcements that we have, and Wes is going to talk about a few things. I'm here with Wes Stefanik, our CEO for DAR, and Andy Taylor, our legal counsel, and I'm Chrissy Steele, your president for 2023. So I hope you like the video of the convention. We had a really, really great convention this year. I know we changed things up a little bit. Rather than doing a lot of CE, we did some micro classes. We had a great trade show, got a lot of really good positive feedback about it. The venue's a little bit smaller, but that's where we were, and at the beach. If you came, you stayed for the 80s band. It was a fantastic time. I think it was probably one of our best conventions that we've had in a while, and I just really want to thank the DAR staff for putting it on, and then putting out this video as well. So Wes, you want to say anything about convention?
Yeah, I just also want to thank everyone that actually answered our survey that we did. We actually had it for 3 different audiences: those that didn't attend, those that attended, then our sponsors and our vendors. And we had great feedback. We're going to use a lot of that to kind of figure out what to do with the coming year. There's big issues with our convention in terms of trying to figure out the location and logistics, which really kind of dictate the rest of the convention and how it looks. But we got a lot of great comments, so we are definitely going to restructure it based off of those. And hopefully everyone comes to our event next year. It should be a great time.
Yeah, good time. Good time. So I do want to say that your chat is enabled. But we're going to ask you, if you have questions throughout the presentation today, to go ahead and post them right into the chat, and make sure that you select the questions, that you're sending your questions to the questions person, which is actually me. So I'm Christy today. I'm also questions today. But make sure you're sending them to me so they come right to my computer, and I'll be able to pose your questions to Wes or to Andy, or maybe I'll be able to take one from time to time. But yeah, I'm going to make that announcement just a few times, probably throughout today's agenda.
Yeah, do you want to go through the agenda?
Sure. So our agenda we have up in front of you today, we're going to talk about convention just a little bit. We did. Wes is going to talk a little bit about the sexual harassment that occurred at NAR and the reason behind our policy here at DAR, which we have as basically a zero tolerance policy for harassment at DAR. We're going to mention the lockboxes in Delaware. There's been some discussions about lockboxes, reciprocal access, and that. So we're going to talk about that for a little bit. We have Andy here. We're so fortunate to have Andy. He's going to give us an update on the NAR lawsuits and what that means for Delaware, the impact for Delaware. And then sort of to round everything up, Andy's going to give us some tools for the competitive marketplace. Reminder, put your questions in the chat. We also have some really good resources. Thank you again, Andy. Thank you, Wes. So go ahead and if you can do a screenshot to save that link down there at the bottom, or click that QR code, scan me. It's going to take you to a Dropbox where there's going to be a lot of resources. All the things that we talk about today are going to be right there in that Dropbox. As we move through the slide deck here, the scan me, the QR code is going to appear on several slides. So if you don't get it right now, it's still coming. We've got a few more slides to go.
And actually, if you scan the QR code with your phone, you can bring that up. It'll bring you right up to a Dropbox tool. Within the Dropbox, Andy will be covering many of these different documents, but we wanted to include it here just so you can see what is in there. But again, Andy's going to be addressing most of those. So I'm going to dive right into, we did mention the survey. Again, thank you everyone that did submit for the survey. Again, I just wanted to briefly mention the options for the event. It's a facility problem that we have. There was a lot of great feedback, though. We had great classes. We had a lot of instructors come from out of state, a few within state. But our last convention, we seem to be changing it every year after COVID, but hopefully we're settling on a format that makes a lot of sense. I think everyone did enjoy it. You could see from the video that we did enjoy it, but we are looking at the options. We have only a few facilities that can handle a convention of our size without breaking our budget, but we are hard at work on that for next year. So briefly, I also wanted to touch on the sexual harassment that everyone may have heard at NAR in particular. Unfortunately, this occurred at a very large scale that made national news in the New York Times. The president of NAR had to resign in the middle of his term because of what he had done, allegedly. And long story short, the National Association has put together a 75-member culture commission. It's made up of staff and NAR members, which includes 33 general members throughout the country, 25 NAR staff members, and 17 staff members from local and state realtor organizations. They're also being facilitated by a third party. It's actually a professor from one of the universities in California who is pretty much an expert in sexual harassment within organizations. And he's helping facilitate the changes that are going to come to NAR with what had happened. One of the first items that they did change as a result of the commission meeting was they did put together a hotline. It's for all members that volunteer at NAR and anybody else involved with NAR, as well as staff. This hotline goes directly to a law firm that will investigate anything that comes up through that phone line. But with that, at DAR, I'm sure many have saw the weekend that the New York Times article came out. Chrissy and I have put out a statement about how we viewed it and our zero tolerance policy here at DAR. Once we released that statement, we also then decided to also review our policies, and we brought it back to our board of directors, which at our last board of directors meeting, we revised our own harassment policy to make sure that it's good to go for the future. So with that, we can go to the next topic, which is the lawsuits.
Lawsuits, that's me. Hello, everyone. Andy Taylor here. Here's your main message for the day. You've got this, okay? Have confidence in yourself. Think about the things we'll talk about today. Read more about it. Decide where you're going to be in the competitive marketplace in real estate in Delaware. And I have confidence in you that you can do it. And we're giving you some additional thoughts and tools today. This is Andy Taylor today. This is not anything official from your board of directors or association or any of my clients. It's just me. All right. So here we go. And so I'm sure you've heard of the jury verdict that was handed down a few weeks ago out in the Western District of Missouri, U.S. District Court there. So that was the Burnett case. And we have some thoughts about how to proceed with this. NAR has been very strong that they are going to appeal on this. NAR seems very confident that they are going to prevail on the appeal. I think basically based on the standard that the court instructed the jury to use in considering the case as it being an antitrust, what's called per se violation, rather than looking at it under the rule of reason and realizing that the rules that were under question were actually pro-consumer, pro-competitive, and good for the consumer in the marketplace. On the screen, there's some summary then of the antitrust claims, and I didn't write this. I took it right from, this is the document that they filed with the court for trying to have a couple of the settlements that were made approved by the court. The court gave its preliminary nod to it last week, so that's good. Final approval of those who settled won't come for a while, but here's the basics of what the case was about. Cases are about, and copycat lawsuits filed since then. So you'll see these have been pending for some years now. The Morrell case in Illinois, filed in 2019, alleges that on behalf of home sellers who paid a broker a commission in the connection with sale of residential real estate in 20 multiple MLSs in 19 states, alleged that was violation of antitrust laws for the reasons we'll see below. The Burnett action, which was the jury trial that was just decided, was filed April of 2019. And that involves sellers who paid a commission for residential sale listed on one of any of the 4 MLSs in Missouri that were part of the case. And the plaintiffs in both these actions allege that the National Association of Realtors and the nation's largest brokerage firms that were part of the case violated the Sherman Antitrust Act, that their actions artificially inflated the cost of commissions in residential transactions, and alleged what they called longstanding conspiracy, agreeing to abide by these NAR rules listed here, requiring sellers to make a blanket unilateral offer of compensation to real estate brokers working with buyers, and restraining negotiation of those offers, denying buyers information on commissions being offered, allowing buyer agents to say that their services were free, and incentivizing and somehow facilitating steering brokers towards higher commission listings and away from discount listings. NAR vehemently denies that this conspiracy was happening, and plaintiffs claim that these challenge rules are anti-competitive and cause them to artificially pay inflated broker commissions when they sold their homes. I have a very different view of this, just stepping aside from the antitrust point of view of it. Words are a big part of what I deal with as a lawyer. So I think it's good to occasionally step back and look at those words. So look at the word broker. What's a broker doing? A broker is making a market in a product or service. So your brokers, your agents, you're making a market in real estate. I don't need to tell you how complicated the real estate transactions are. And my view, contrary to what was said here, that they feel sellers paid artificially inflated the cost of commissions, I feel your services as brokers help those sellers to derive fair value for their property, which was higher if your services were not involved in that. And so you have actually helped sellers to derive value from their properties. Just telling you a little joke on myself. I'll come home with something sometime and say to my wife, Robin, oh, look what I've got here. I think this is worth blah, blah, blah. And she'll say, and it's only worth that if you can find somebody to pay you for that. So you're brokers, you're making a market in real estate, you're finding those sellers, you're finding the buyers, you're bringing the parties together, you're making that market in real estate. Bright's done an interesting study recently, and they found, I think it was 23%, 23% higher value derived from properties that were marketed through the MLS than those that were marketed off the MLS. And I think Chrissy, NAR did a recent study as well.
Yeah, NAR did one too, and NAR says that 90% of sellers use a broker to sell their property, and of those 90% that use a broker to sell their property, that on average they sell for 30% more than for sale by owners. And so you're talking about the broker marketplace, the marketplace that brokers create. I love that, and I love the story that you share about your wife coming home.
She's right.
Yeah, my husband's the same way. He collects stuff and it's like, oh, it's worth blah blah blah. And I appreciate that, but I used you in an example this morning when I was talking to somebody about that. It was a great illustration.
Yeah. So give yourself a pat on the back. You provide a lot of value to the public in making this market in real estate. So anyway, the interesting thing we had to deal with then is, sure, NAR is appealing this. The appeal is going to take a couple of years. So what do we do in the meantime? Well, we're not going to wait because we have some very good guidance. There were two of the defendants in the suit that settled prior to it going to the jury. Anywhere, which was previously Realogy, and Remax, they both settled. And Anywhere put out a very handy fact sheet summary, which I think is in the Dropbox, that talks about the terms that they settled. So I'm not going to focus on the money today. What concerned me more when I first heard they had settled was it said that they had agreed to make some changes to their practices and procedures. So we have a good outline of that now. It was fleshed out further in the document that the court looked at last week as far as the and so with the Anywhere settlement, this covers the brokerages that are under the umbrella of Anywhere, divided in a couple of categories. First of all, those that are part of the Anywhere corporate brokerages. So could be a Coldwell Banker Realty, Corcoran, Sotheby's International Realty, that are brokerages owned through Anywhere. And then Anywhere brands are also covered, an independently owned and operated Anywhere franchise, which would include Better Homes and Gardens Real Estate, Century 21, Coldwell Banker, Corcoran, ERA, or Sotheby's International Realty. So this summary sheet, when you look at it, you'll see it breaks down some things with those that are the Anywhere owned, those that are the brands that are independently owned franchise networks. So this gives us some very good guidance. I'll review some of this with you today, and I think you'll be able to see we got this. Okay, you can deal with this, and we have tools for you already in place to deal with it, and we'll be taking a look at maybe some enhancements to those as well going forward.
Are you ready for your first question, Andy?
Sure.
Okay, so as we said a little bit ago, and for those of you that have joined in the last few minutes, make sure that any questions you have that you're posting in the chat, and you're sending them to questions. It's the word questions with a question mark after it. It's also me. So they're coming to me. So I'm going to get the questions and then pose them to Andy or Wes, or every once in a while, like I said, I can answer one. First one, I'm going to answer myself. Michael Herrera says that his brokerage's legal departments review the DAR buyer agency agreement. They don't really like it. So he's asking basically what to do. And I'm going to answer that one. Listen to your broker. Always listen to your broker. But the next question for you, Andy, is need some clarification regarding the word cooperation. Agents in certain counties are not offering one-day codes and not making efforts to blah, blah, blah. So the question that he's getting at here is, can you define cooperation for us? And I think Delaware agency defines, or Delaware statute defines cooperation, and so does NAR's Code of Ethics. So can you define cooperation for us?
Sure, was coming to that, but let's do it right now.
There you go.
So as Chrissy mentioned, so Article 3 of the NAR Code of Ethics states that realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include the obligation to share commissions, fees, or to otherwise compensate another broker. And then within our Delaware Licensing Act, and this is number 4 in your Dropbox, I gave you a copy of the statutory provision in Delaware on duty to cooperate, section 2935, and basically starts out similar to the NAR Code of Ethics, except rather than saying realtor, says licensee shall cooperate with all the other licensees involved in a transaction, except when cooperation is not in the customer's or client's best interest. The obligation to cooperate does not include any obligation to share commissions or to otherwise compensate another licensee. It goes on then to say, in order to cooperate, licensees shall be reasonably available when requested by their customer or client to accept delivery of and present client and customer offers, counter offers, so to participate in that negotiation process, assist the customer or client in developing their negotiating strategy, communication, presenting those offers until the agreement of sale is signed and contingencies are satisfied or waived, answering the customer or client's questions relating to that negotiation process and contingencies, and hold the escrow deposit. Now, that doesn't say that you have to provide all those. It says reasonably available when requested by their customer or client. And I'll come back to that in just a second. And so then part C says, in order to cooperate, licensee shall be reasonably available when requested by a cooperating licensee to undertake these activities that we just looked through, but only if their customer or client has given written authorization to provide those services or undergo that requested activity. And if the customer or client is not giving consent for the licensee to do those activities, then they will not. They're not including that then in the brokerage services they're offered. And so to give you a little bit of background on this, this has been in Delaware law since our 2007 statute, and it has been, this section of our code has been approved by the United States Department of Justice by a letter I received from them, certified mail, sent to me March 23rd, 2006. So this section in our Delaware law has been approved by the Antitrust Division of the Department of Justice. So that gives us good cooperation there. I can tell you what they were concerned about at the time, which is very relevant to us now in our discussions, is they wanted to make sure that Delaware law facilitated different brokerage models. And this is a big point of today. It's up to you, your broker, your company policies to see where are you going to be in the competitive marketplace? What brokerage services are you going to offer? How's that going to be communicated to the public? How's that going to be documented with agreements, your listing agreements, your buyer agency agreement, and then conducting yourself in the competitive marketplace? So this section approved by the DOJ is very consumer friendly, makes it clear that brokerages can offer a menu of services if that's the way they want to offer their brokerage services, or they can offer all the brokerage services that are described in the consumer information statement from the Delaware Real Estate Commission. So that's how duty to cooperate is defined in Delaware. And you'll see a lot of it relates back then to what you say in your buyer agency agreement and your listing agreement as far as what you're doing for your client. So, and that ties back in as well with looking at these changes, practice changes that are being agreed to as part of the settlement of these lawsuits. And so anywhere prohibits the agents from claiming that their buyer agent services are free. Well, they're not free. We know that. That's not new news to us. And it always tickled me a little bit that sellers saying, well, they're paying the commission. It's sure it's shown on their closing disclosure, but ask a buyer, who's paying the commission? Whose money's on the table? Buyer says, oh, it's my money on the table. So you ask the buyer's paying the listing agent and paying the buyer's agent because it's their money on the table. That's a way of looking at it as well. So certainly the services aren't free.
I love when you explained it that way. I just want to say that real quick. I was writing some things out just to understand them a little bit better myself. And, I give it to my husband, who's like my litmus test. If my husband, who's a very, very smart person, but if he can understand it, he's not in the real estate industry, does it make sense? And when I was writing out your explanation of, well, who pays the real estate commission fees, it's always been a circular argument, buyer, right, seller, but then you put a different spin on it. Well, wait, the transaction pays for it.
That's right.
And when I wrote it out, my husband, Sean, he was like, that makes sense. That's a good point. I've never thought of it before. And
Yeah.
so that really resonated with him, even
Good.
somebody who's not even practicing real estate.
That's good. And I think that's a good example then, a good vocabulary for you to think about using and working with the public is the agents are paid from the transaction. So you're paid from the transaction, whether you view it as seller or buyer, that money is all part of the transaction. You're paid from the transaction. And as I mentioned before, I think your involvement, helps there to be that, the brokerage helps there to be that marketplace made for real estate. And going on, looking at other parts of the settlement, and that is that there will be included in the published listing the amount of compensation that's being offered to a buyer's agent, which, as we know, can be zero. The Bright MLS rules say that the compensation offered can be zero. And prior to that, it could be as low as $1. So that's effectively, in my view, the same thing. And
NAR said the same thing too.
Right.
It's absolutely in keeping with, $1 or zero. It's almost the same thing.
Exactly. So part of this is that with this settlement, they want things to be more transparent to the public. So they want buyers, when they're clicking around, looking at online listings, they want the buyer to be able to see the amount of compensation then being offered by the seller to the cooperating buyer's agent. And then the settlement says there will not be technology used or manually used to sort listings by the amount of offer of compensation. And I think, Chrissy, you told me that's disabled in Bright anyway. You can't even search that way.
Yeah, it has been for I think it was under, I think they did that with like the clear cooperation policy when it came into effect. Is we used to be able to go into Bright and when you click through to the results screen and it comes up with the with the table where you can add your own fields, customize the look, and then sort alphabetically, numerically, whatever. That was probably done away with maybe close to 2 years ago, a year and a half, 2 years ago.
Good. So
we can't view, and so we can still see cooperation and compensation. We just can't display it in a way that allows us to sort by that.
Good. So you see, that's already done here locally as far as this settlement goes. And next part of the Anywhere settlement is that make clear to the public that Anywhere as a big umbrella company doesn't have rules requiring offers of compensation. And remember, though, those licensees within a particular brokerage, they're all on the same team. So there can be company policies for those independently owned franchises. There can be company policies and discussion within the company about your compensation structure and how that's presented to the public. You don't have to work for free. You're not even saying you're working for free because you're not working for free. Of course, you're being compensated in some way. And so that then can have those discussions within the company, and there can be company policies on that and explanation of that to the public. And then the another practice change here for the company, for the big Anywhere owned brokerages, they will not have a rule requiring NAR membership. Independent brokerages, well, even those within the company that own brokerages, of course, they can decide, of course, to maintain their realtor membership. Next practice change is they want there to be clear disclosure to clients that commissions are not set by law and are fully negotiable. My thought here locally on this is the DAR Forums Committee will be, as the question indicated, we'll be taking a look at the DAR buyer agency agreement and listing agreement. This is one of the things we'll add to that, is to clearly say that commissions are not set by law or regulation or fully negotiable. Again, then within the company policy, just because they're negotiable doesn't mean you have to work for free. You could have pro bono real estate services, I suppose. Maybe you're doing some pro bono brokerage for your church, synagogue, mosque, whatever, local parks organization. If you want to offer free brokerage services to help out that way, just like lawyers do some pro bono service, but that you could have that within your policy. And then commissions then are negotiable. That will be clear. So this is where more of your discussions will come into play with sellers and with buyers. So you will be more carefully, in my view, reviewing the listing agreement and the compensation terms in there. You'll be carefully reviewing the buyer agency agreement. And again, in your Dropbox, you have the current version, number 6 and 7 in your Dropbox are your listing agreement and your buyer agency agreement. And those, spell out how have the blanks there for your discussions with the seller about your commission structure, blanks on the buyer agency agreement for the commission discussions, and a simple sentence in the buyer agency agreement that if the compensation offered by the seller does not meet the amount of compensation that needs to be paid to the buyer's agent, then the buyer agrees to pay the difference. And I like Chrissy's. I think you have a good way of explaining each blank.
Yeah.
Go ahead.
Yeah, it just each blank is there for a reason. And every time you see a blank in a form, it's meant to promote a discussion, a dialogue, and it's an opportunity, when you're sitting there with your buyer and seller. And I mean, I know most of us don't do this anymore with a pen and paper, wet ink and all that at a table. But okay, so compensation is this field. Okay, so let's talk about that. Even the expiration period, let's talk about that. The protection period, let's talk about that. So every blank is meant to have a discussion.
So that's good. And I think, this is a practice thought for you. It would be very difficult to have a buyer call you at 10 o'clock in the morning and say, hey, thanks, I see this listing just hit. Can I meet you there at 3 o'clock? Well, I'm happy to take your call and glad you contacted me or texted me or whatever. But think about that. That's going to be difficult then as your first contact meeting at the property at 3 o'clock. I think, in my view, a better practice is to have a buyer counseling session with that buyer, get together with them face to face or do a Zoom with them, provide them with your buyer agency agreement, provide them with your other company disclosure forms, talk with them about the realities of the real estate marketplace, educate them as to the whole buy-in process. And I think you go through a well-presented buyer counseling session, that buyer will be wanting to sign up with you on a buyer agency agreement. As you know, you can represent a buyer in Delaware without a written buyer agency agreement unless you're seeking to have that be an exclusive relationship. Then buyer agency agreement needs to be in writing, or if you're seeking to have that buyer be responsible for paying you any compensation, then that buyer agency agreement needs to be in writing and signed by the buyer. So, my suggestion is you have that buyer counseling session, and then go ahead and educate them, talk about your buyer agency agreement, and proceed accordingly, then meet them at 3 o'clock at the property. So if nothing else, do it as a Zoom before you get there to meet with them. Now, going back to these antitrust cases, there have been some copycat lawsuits filed since then, and then those obviously will be defended, but again, it's going to take a couple of years. So it seems to me we have very clear guidance from the settlements that were reached with Anywhere and with RE/MAX about the things that the plaintiffs and the court wanted to see change. So in my view, let's just deal with those now. And we'll go forward from there, which brings me back to, have confidence in yourself and your brokerage organization that you can deal with this. And we will be looking at things closer here in Delaware. I think we're very well positioned, very pro-consumer in Delaware. We have the immediate duty of confidentiality upon first contact between a member of the public and a real estate licensee, whether you've discussed representation or not at that point. That immediate duty of confidentiality, the presumption of consent to representation, and the presumption of consent to the disclosed dual agency documented in the consumer information statement. And yet the member of the public has the chance to opt out of that. If, for example, if they didn't want the disclosed dual agency, if they thought they wanted to opt out of that at that point, they could do so. If they later decide that's okay, you can sign a different CIS then to say they're okay with the disclosed dual agency. And so I think our forms are well set up by that. I think I'm hoping that the Delaware Real Estate Commission will take a look at the CIS, maybe add a few sentences. I've just jotted down some things I had in mind that they could say right on the CIS, compensation to real estate agents is not set by law or regulation. Compensation is negotiable. You should discuss compensation with your real estate agent. Brokers can set their own compensation schedules based on what services are offered and their business model in the competitive market. And just still thinking about that, but that's just some thought I've had to jotted down some notes there as far as how that might be a good enhancement to the consumer information statement from the Real Estate Commission. That should carry a lot of weight with the public because it's a state of Delaware Real Estate Commission form that sets that forth right there. And that would be certainly right in line with the lawsuits. And
I like the way you approach that too. Sort of putting it right into the consumer information statement, because now it's an opportunity for another discussion. And I was meeting with somebody in my company this morning, and every time they talk with a buyer, they sit down, they say, oh, here's the consumer information statement. This is not a contract. By the way, this is our agency duties. This is what it looks like when we work together. And then they flip it over to the buyer agency agreement. This is a contract. Now let's talk about that. And to make the distinction between the two, the CIS is not a contract. The buyer agency agreement is.
so just cover some more points here with you. And so in the information in the Dropbox, let's talk about if you are dealing with a situation where you've had that good buyer counseling session, you have compensation language in there, you've set up a good tour for buyer looking at properties, there's a property they're interested in where the seller is not offering the amount of compensation that is being charged by the buyer's agent, then how can you deal with that? And so this is another item in the Dropbox. And let me bring this up here. Number 8 within the Dropbox.
Oh yeah, that's a couple of our questions that we've had come in already, and I know you're gonna share about that. But a couple questions we had come in, Andy, just to I guess to lead into that.
Okay.
Todd Stonecipher says, in Andy's explanation, if no compensation is offered to the buyer brokerage, how will the brokerage be paid from the transaction without something creative found in the offer? And could that be a code of ethics violation, which I know you're getting ready to speak to? And then Marcia White also asked the question, do you see a change to the agreement of sale in section 32 or in section 30 about the brokerage fee? Do we anticipate a change in the agreement of sale coming?
You all are so smart.
I know. Right?
Todd, Marcia, you got to yep. So you can take a look at number 8 within the Dropbox, buyer compensation language for the agreement of sale. So yeah, just as I think Marcia's question indicated, yes, paragraph 32 in the agreement of sale, giving you some simple language here. You could put seller agrees to pay selling broker, parentheses, buyer's agent, dollar amount or percentage amount of the purchase price at settlement pursuant to the brokerage agreement between buyer and selling broker. You don't have to use those exact words. You've got the concept, but you see, yeah, that's short enough, right to the point. You could put it right in paragraph 32. To part of Todd's question there, doesn't this violate the code of ethics? Well, no, for this reason. Let's look, standard of practice 1616 says realtors acting as blah, 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 shall not use the terms of an offer to attempt to modify the listing broker's offer of compensation, nor to make the submission of an offer contingent on the listing broker's agreement to modify the offer of compensation. So as you can tell from my emphasis there, that standard of practice focuses on the conduct of the agents, not the conduct of the buyer and the seller. So the offer being presented on the signed agreement of sale with this language in paragraph 32 is an offer by the buyer to the seller. And so that is their conduct between the buyer and the seller. The standard of practice prohibits the buyer's agent from trying to modify the behavior of the listing agent. That does not stop the buyer and the seller from agreeing that the seller, not the listing agent, will pay compensation to the buyer's broker. So that gives you, we've mentioned in our agenda, some tools for you. Here's a tool for you to think about. Again, not as an individual agent. You'll talk with your broker, you'll talk with your company, have company discussions about it as to how you would proceed in that kind of situation that was mentioned.
Yeah, no, that's really good. And Andy, just coming out of the pandemic and the really, really heavy and highly competitive sellers market that we saw. I mean, we saw a lot of creative things go into offers that buyers were putting into offers. And I'm sure almost everybody on here saw the same thing, that there were times where a buyer writing out part of their offer would agree to pay some of the seller's expenses, whether it's commissions or whether it's the transfer tax. Now, in your mind, do you see any difference between a buyer offering to pay some of the seller's closing costs and then a buyer maybe asking for a seller credit? I mean, these are all costs related to closing and related to the transaction that the parties are really just negotiating, right?
Correct. And also, we're fully aware, don't worry, that the lending world needs to figure this out.
Yeah.
Because are they going to want this presented as compensation to a buyer's agent? Are they going to want it presented as seller settlement help? We're fully aware the lending world is going to be dealing with how do they work this out for VA loans. So, we're working within the brokerage community of how do we deal with this. Believe me, all the other parts of the real estate world are figuring out how they figure it out and work with it in their world. So I want to mention, again, go back to your buyer counseling session and also in dealing with sellers. And now this is just Andy, remember, just stepping back and purely me, just looking at something. I'm going to find it very interesting, just strictly from an intellectual point of view, to see how this shakes out in the marketplace and what different company brokerage policies there may be offered in the competitive marketplace. So just Andy intellectually is going to be very interesting to look at that. And some tools to help you think about that. NAR's put out a couple things. Again, within your Dropbox, they have 179 ways. This is Dropbox number 9, 179 ways and 105 ways here presented from the title of the 105. 105 more ways agents or realtors are worth every penny of their compensation. Look at all the things big and small that a realtor may do to help clients when buying a home. So going back to my point that you need to think about things within your company. So what's your position going to be in the competitive marketplace? Are you doing all 179 things plus all 105 things? I doubt it, because some of those things we don't even do in Delaware. So, but that's some tools you can take a look at. And then I encourage you to talk about that within your company. Say, all right, well, here's the services we offer. Here's our menu of services. Here's our compensation schedule that goes along with that. Are we offering full brokerage services defined this way? Are we offering more limited brokerage services defined this way? A menu of services defined this way? What's the compensation that goes along with that? But don't ignore these things. And again, just Andy talking, I have a little concern that NAR puts some of these things out and there can be unintended consequences. I think an unintended consequences of these 179 things, 105 things is after a transaction. And despite everybody's best efforts and everyone involved in the team of getting the whole transaction through, something turns out to be a problem afterwards. And somebody's looking back at the 179 ways and says, well, if you had done 144, this wouldn't have happened. Well, I don't offer to do 144. Maybe we don't do that in Delaware or whatever. So in some ways, the public's going to be a little bit confused by these. So you can't be confused by it. You need to look at these kind of tools being put out here, decide what's your brokerage model, what's the services that you're offering to the public, and your compensation schedule that goes along with that. So
I like that. It's almost like these 105 ways that it's a menu of services, and you pick and choose which ones are going to go into your value proposition.
Great words there, your value proposition. So you're going to have to do more explanation to the public of your value proposition. I love that, Chrissy. And make sure the public then understands. So here's why I'm hiring you. Here's the value you're bringing to the transaction, and well worth that compensation. By the way, as a buyer, I would pay you more than you're requesting, because I want more service than what's offered in the 179 and the 105 ways. I want you doing absolutely 110% out there beating the bushes in this tough marketplace. finding that property for me, and I'll be willing to pay you more for that.
So there's 152 people on the Zoom right now, Andy.
That's right. Okay, there you go.
Right after that.
Well, I'm not in the market right now, but I'm just telling you, there's good argument that, somebody looks at things, and as a buyer, you can explain to the buyer a few other suggestions for you. When you're talking about compensation, they just need to be clear on that before they make an offer. Are they offering this and the agents are paid from the transaction? Or is the buyer offering this and then the buyer paying their agent this? They're still paying that. It's still the same total. They just need to know before they make that offer there for the property. And then that's a good way that it can work. Another suggestion I have for you, this is just Andy, but in dealing with a seller or a buyer, say to the seller, never tell me your bottom line of what you would come down to. Oh, well, why is that? You're my agent and things are confidential. Well, yeah, but just never tell me that. Because if it just happens that a buyer's counteroffer comes back and hits it right on the money for what your bottom line was, I don't want you thinking that I told them that. Because if you don't tell me, I can't tell them. The best way to keep a secret is not tell anyone. You hadn't figured that out already. On the buyer's side, say to the buyer as part of your buyer counseling session, never tell me the maximum you'd pay for a property. Why is that? Well, because if the seller's counteroffer comes back and nails it right on the money for your top price that you would pay for that property, I don't want you thinking that I told them that. Because first of all, I wouldn't. Things are confidential. But still, if you don't tell me, there's no way I can tell anyone else. So some things like that. And folks, you do this much better than I ever could. So you'll develop those type of ways of discussing with people. I'll tell you, I think gone are the days when the buyer wants to make an offer. You say, okay, I'm sending this over, just sign it electronically. And 45 seconds later, you get it back with signatures and initials everywhere. Well, is that really the service that the public expects or should expect, or that you take some time like it used to be done? When it was paper, you actually needed to get together with people. You'd have 45 minutes, you'd have 2 hours, whatever it took to really go over that agreement of sale so they understood how they were making the offer. Another great thing you can do, as part of your buyer counseling session, I'm sure you're already doing this. You're giving the buyer right up front before you even see the first property, a blank agreement of sale, perhaps going over it some with them at that time. And that way they're very familiar with it. Yeah, sure. If you spent that time with them, they might be able to just do the 45 seconds to sign an initial because you've already spent the time making sure they understand what they're signing. So that's just another suggestion for you there.
Yeah.
And have these discussions within your company. Do some role playing. I come back to you got this. Okay.
I love role playing. I think that's a practice that we've kind of gotten away from some. I think some agents, some teams, some brokerages are really good at it. And role playing, I heard somebody say one time, don't practice on your paycheck. Role playing affords us the opportunity to practice when our paycheck is not on the line.
Another thing you have within your Dropbox, number 5 there is a compensation fact sheet that's from NAR talking some about compensation. So just another good thing for you to look at. And I'm going to pause at this point here. So.
Yeah, Andy, did you, I just want to go back through your slides here. Did you have any more on any of these points that you wanted to make?
We talked about compensation. We talked about the presumption. We talked about the CIS. So I think we pretty well covered a lot of the points there. And just to mention as well, I'm sure you know this, but you do not need to be a realtor to be a member of Bright MLS. This was also the case with the prior version of the MLS called Trend. So that's been decades in Delaware that you've not needed to be a realtor to be a member of the Bright MLS. I'm sure NAR will be looking further at the code of ethics, see if they think they need to refine anything there further on that. Many years ago when buyer agency was first coming into play, so this is in Delaware around like 1987, 88, there was one national convention where NAR made 40 changes to the code of ethics. And that was at the time that they were taking out of the code of ethics anything that made it appear that there was only seller representation, and to acknowledge the fact that there's buyer representation. Fair housing implications, I have some personal concern about with some of these antitrust cases and the perhaps change in the structure of compensation, how's this going to impact, particularly first-time home buyers? Is this going to have any fair housing implications as far as discrimination in the marketplace? So I'd ask you all just to be sensitive to that, aware of that, and remember that Delaware's Fair Housing Act is very strong in that if you're working with a member of the public that you feel has been discriminated against in violation of Delaware's Fair Housing Act, you can be a plaintiff, you can be a complainant in that because you are within the definition of Delaware's Fair Housing Act, an aggrieved person. And that's stronger than the federal law because for the federal Fair Housing Act, you can only be an aggrieved person if it's disability discrimination. In Delaware, you can be an aggrieved person if it's any of the 13 protected statuses under Delaware's Fair Housing Act where there's alleged discrimination. So I'd much rather have you be a complainant in a fair housing matter than a respondent. So continue to be the strong advocates that you are for fair housing.
Yeah, no, it's good. It's good. So, okay. So, just remember that Scan Me QR code is up there at the top. Any questions that you have, put them in the chat and make sure you select questions. All of Andy's documents are in there as well. In the Dropbox that the Scan Me takes you to. I think a couple people said that they didn't have access or they couldn't get the Dropbox. If you told me that, I have your name. We'll make sure that we get you those documents. Are we ready to talk about lockboxes?
Yeah, real quick though, we are getting a lot of comments that we will not get to answer all of these today. So
Okay.
we'll try to follow up the best we can later. But
Are they not coming to questions? Is that?
yep, and there's a few others here that we have to just do a little more research for too.
Okay. All right. Sounds good. So, moving on to lockboxes a little bit, I do want to address just some recent discussions that we've heard surrounding realtor lockboxes in Delaware, particularly the calls for a statewide lockbox program. It's important to note that each of the 3 local associations, and whenever we use the term local associations, we're talking about the Sussex County Association, Kent County Association, and Newcastle County Board. But each of the 3 local associations, they all have individual contracts with Century Lock or Century Key. It's one or the other now. And each contract has its own unique terms. So even if there is a desire for the 3 local associations to consolidate all the lockboxes into one big statewide program, the terms of each contract needs to be carefully reconciled and consolidated into a single agreement with Century Lock. So it's crucial to understand that the State Realtor Association, we have no authority whatsoever over the local realtor associations, especially when it comes to services like this with the lockboxes. Now, we do have a little bit of limited authority, just for full transparency, that comes from NAR, and that is really only in making sure that NAR's core standards requirements are met annually for the local associations. Aside from that, the local associations, they're autonomous. The authority that we have, it still does not allow DAR to ever take control of a lockbox program. And I know that a few members have suggested that. What we do, though, is we encourage you to reach out to your local association, whichever one's your primary member of, secondary member of. If you pay for Century Lock service only for one of those, whatever your affiliation is with that association, please reach out to them to delve into the specifics of their lockbox program and whether or not it currently offers reciprocal agreements to other associations. We did hear this morning that the Newcastle County Board did just reinstated their reciprocal agreement with Kent County. So for those of you in Newcastle and those of you in Kent that were relying on that reciprocal agreement, we did just hear that that's been reinstated. Now, your local leadership, I know that they're anxious to hear from you. In Sussex County, Allison Stein's your president. In Kent County, Bobby Slagle's your president, and in Newcastle County, Scott Farnan's your president. You know who the staff is, you know the leadership of each association. Please reach out to them because they're eager to hear your thoughts and your opinions as it pertains to the lockbox service and really anything. I know even on the state level, I'm always anxious to hear from members about your opinions and your thoughts on the services that we provide. and the advocacy, especially at the state level, that we provide. So I'm going to jump back into the questions and see if there were any more. Okay, so one person asked, can DAR administer a statewide lockbox program if the local associations consent to it? I'm going to change the word consent because if they consent to it, could DAR? I mean, we're an organization that we could, but it would have to come with specific instruction and requests from each of the local associations, all three of them, to get together and basically say, hey, this is what we want. DAR would be happy to have talks with the associations, mainly to help facilitate something. But no, even if the locals consent to it, DAR does not step in and take over anything that the local associations are doing. One person asked, isn't it our role to provide leadership to the local associations? Actually, Wes, can you answer that question, the role of the state association as it relates to the local associations?
Sure. Yeah. So the way the structure of the National Association functions is it's a federated organization, meaning that we have this idea of a three-way agreement that since it's federated, there's a national association, a state association, a local associations. We all get our charter, the state and the locals, we get our charters from the National Association, but this framework works out well because you become a member of all three once you join your local association. So, we don't really have any sort of we have limited roles based on our charter, but we're not a supervisory body to local associations. Again, like Chrissy said, each association has to meet core standards, which is a whole list of requirements that each association needs to meet at a minimum level to operate and to maintain a charter. But again, the state association doesn't have some sort of like overriding authority over the local associations. We're independent, just like the three of them are.
Okay. Now, this question is...
May I tell a funny story?
Oh, yes, please. Gosh, Andy, I love your funny stories. Please do.
So, decades ago, just beginning representing realtor organization here in Delaware, and I've heard of this three-way agreement. So I'm actually at one of the NAR legal counsel seminars, and fortunately, I didn't ask it during the big session, but I pulled aside one of the NAR lawyers and I said, so this three-way agreement, could you get me a copy of that? Being a lawyer, I like to read agreements, like to know what they say, and he said, there isn't one. Mm-hmm. I said, what do you mean there's one? It's a three-way agreement. Where's the agreement? Let me read the agreement. So, so it's not something that's written down in a contract saying this is the three-way agreement. It's by the charters, it's by the NAR set up as a federated organization.
And to learn, if you're interested in diving more into that, which definitely wasn't on the agenda today, but
sorry.
No, that's fine. If you the easiest way to get to it is if you Google the NAR Constitution and bylaws, you can read all about it right from the governing documents.
Right. But there's not something that DAR is signed or your local association is signed saying this is our three-way agreement. So
yeah, it's funny enough.
You just have to kind of figure it out by looking at the Constitution, bylaws, and governing documents.
We were having a conversation yesterday about it. It's interesting because DAR as a legal entity was created later than the three local associations in Delaware, which I don't know what happened back then, but it was interesting to learn because I thought it would have been the opposite at a minimum. But
yeah. Okay, so we do have a few more questions. So backpedaling just a little bit, there's a few questions that come up in here, and I don't want to skip over them. Just asking, well, is they're naming certain behaviors, and then is this a violation of the Code of Ethics? And so when we talk about the roles of the associations, the local and the state, in Delaware anyway, it's the role of the local association to enforce the Code of Ethics, to conduct professional standards hearings and the whole process. And so I just want to, draw attention to the fact that what determines a violation of the Code of Ethics is actually the hearing panel. It's the entire process. So it's not crystal clear cut to say, oh, it's such and such. Is a particular 5 jumping jacks right now on this table. Is that a violation of the Code of Ethics? It has to go through the whole process. Isn't the legal term adjudication? Is that the wrong word?
That's a good term for it.
It has to go through a whole process to find out if there's actually a violation.
Right. And remember that the entire Code of Ethics manual and everything is online. through NAR. And part of a resource of that a lot of people have not gotten to yet because it's at the very end of it all, is they have case interpretations. So if you are wondering about a situation and they're organized by the articles and by the standards of practice. So if you say, gee, I'm wondering, is this a violation of Article so-and-so, you could go to those case studies, see if maybe you can find one that's similar to the situation you're trying to puzzle through. And because those are considered official interpretations and those can be referred to by hearing panels when they're considering a professional standards matter. So if you haven't gotten that far deep into the manuals, you take a look at those case studies, it might help you as well.
Yeah, good. There's always that joke. Al Monshauer used to do the training in Sussex County, and he's like, "Oh, this, what do we call this? CAEM, the Code of Ethics and Arbitration Manual." He's like, "This is great reading material late at night." And I actually used to do that. I used to take that manual. It's like 400 pages. I used to take it and read it just to brush up on things.
Just one item, though, on this topic, since we're talking about it. So if, for whatever reason, an impartial panel can't be impaneled at whatever local association the complaint comes to, there are agreements in place right now that it can go to another association within Delaware. If it doesn't go that direction, we do have an agreement with the state of New Jersey to actually do a panel if it's necessary. So there are different avenues with that process as well.
Yeah, no, that's good. That's good. There has also been a few questions. I'm going to try to summarize them as they came up. A few questions just about Bright MLS and its rules. So I would encourage you, Bright MLS rules, go to Bright MLS and talk to Bright MLS. They have their own leadership there. They have the rules. Do we have a say in their rules? You know, they want to hear from us. We want to hear from them. We have a good relationship with Bright MLS. And we can take concerns to Bright MLS, and we can take Bright MLS instruction, advice, and all that back to us and back to our members. But specific questions about Bright MLS rules, please direct them to Bright MLS.
And on that point as well, I want to mention, because it's good to know some of these things, because maybe most members might not know this, but DAR as an entity, we actually have no real established relationship with Bright MLS as an entity. Right. Each of your local associations do. They're shareholders in Bright. So we here at this building, DAR, we have no legal connection, if you will, with Bright MLS. Your local associations do.
Yeah. So what you're saying is send questions through the local association?
I am saying that.
Send questions, send concerns about Bright. We obviously do want to hear them, but it is your local association that does have that stakeholder interest with Bright MLS. Okay, so here's a question here, and I'm not sure exactly how to interpret it. I'm thinking maybe, Andy, this is the best question for you. Considering that real estate agents are regulated by state boards, do you believe that a trade organization is more competent than the state government in controlling access to listings? Not totally sure what it's asking, but can you talk for a second just about the difference between the regulatory body, the Real Estate Commission, and our trade association?
Sure.
The differences between the two and the benefits of the two.
Sure. So first of all, I do not represent the Delaware Real Estate Commission. They're represented by a Deputy Attorney General who attends all their meetings and Deputy Attorney Generals who prosecute matters for violation in front of the Real Estate Commission and the hearing officer. So I do not represent the Delaware Real Estate Commission. So there's sometimes people get a little confused on that because I do attend so many of their meetings and try to help with things. But so they're very well represented through the Attorney General's office. And so they are charged with the Licensing Act and the rules and regulations and enforcement of the Licensing Act and the rules and regulations. And so that's their role. And we are very fortunate that at times the Real Estate Commission does ask the realtor world, the licensee world, for input to topics that they're working on, help with some things, and gathering input from members to give input to the Real Estate Commission, with them having the ultimate authority, obviously, over their regulations. The Licensing Act changes have to go, of course, through the General Assembly and be signed by the governor to become law. And so that's somewhat of our relationship there. And obviously there's a lot of benefits to being a Realtor member. It's way beyond the scope of this course, but with my decades of experience, you'd be horrified to hear some of the things that through the years have been proposed in the General Assembly that some of them probably would have gone through if it hadn't been for the Realtor world being there and educating representatives and senators why that's perhaps not the way they want to go. I'll just put it mildly that way. And then they fortunately listen to us and, back off and proceed in a better direction.
Yeah, especially, you're going to hear it coming into next year. The legislature, there's a lot of bills out there that are going to impact real estate across the state. And, from time to time, we do have licensing questions that come up. Most of that can be handled on the regulatory side, but I think next year we're definitely going to be hearing a lot more on this front. So please, one of the member benefits of this association is we're on top of the regulatory landscape, but also the legislative landscape, which is becoming very active since it's the final year of the term coming up.
Yeah.
What's the saying? If
Yes.
if real estate
is your profession,
right,
politics is your business.
Right.
Yeah. That was NAR President Leslie Ruda Smith. Her father, who was a president of NAR, I think decades ago, he was the one that coined that phrase.
That's so true. You want to spend some time in the General Assembly. I mean, DAR's got great staff and committees and whatnot, and they welcome people coming over to the General Assembly because it really carries a lot of weight. If you're walking up to your senator and saying, "Hi, Senator, I live on such and such a street. I'm one of your constituents." Ooh, they're going to listen to you then a lot more than me walking up to them, frankly, because I can't vote for them unless I'm in their district.
Yeah.
So
I do want to just roll back for just a second. And I know it's not really the scope of this. No, you're good. The scope of this meeting, really, the difference between the regulatory, trade association, blah, 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 not blah, blah, blah. It's a lot more than blah, blah, blah. I get that. But no, one huge member benefit that we have is our forms committee. And every time I teach it in my company to a group of agents about the forms, I always talk about the members of the forms committee. And Andy, I mean, your contribution is absolutely invaluable. It is. But one of the points that I make when I teach in my company is that our forms are written by brokers and agents who are practicing real estate.
Right.
It's not just all lawyers. Yes, it's written with you, absolutely. But I mean, it's like the members of the forms committee direct the direction of the forms, the clauses, the terms, all of that, and then you make sure that it's all legal, that it's the way it should be. And I love that because our forms, our statewide forms, are specifically for realtors and realtors only. So our state does not provide any more than the CIS and the seller's disclosures
and the radon
disclosure. Yeah. Federal government provides a lead-based paint disclosure. Aside from that, every form that you use is because of the DAR forms committee.
Offered to you, not required that you use. It's your company policy to decide which forms you use.
Yeah.
This is the disclaimer. This is the footnote here. That's right. Offered to you to consider using on a voluntary basis.
Yeah.
There you go.
Glad you're here.
All right.
Thank you very, very much for that. Yeah. And I mean, talk to your broker too, because I know that there's protections and exposures maybe, as far as E&O is concerned, but absolutely talk to your brokers about that. So
speaking of the forms with it, I think one of the questions mentioned maybe a brokerage company attorney that looked at the form and had some suggestions. I'd love to talk with that attorney. Any of your lawyers that look at your forms in light of everything that's going on in the brokerage world, I'd certainly be happy to talk with him or her.
I do also want to mention very quickly, since Chrissy had brought up the forms committee, one of the initiatives that we did just recently because of everything that's going on, particularly a lot of what Andy just covered within this presentation, is under President Chrissy's leadership, we created a new committee that is called the Licensing and Practices Committee, Real Estate Licensing and Practices Committee, which is where we're going to focus all of these conversations that we're going to have about what needs to be done, whether it be regulatory wise, legislative wise, within real estate licensing. So now we have a single group that is 100% focused on these issues.
Yeah. There was something that we really wanted to work on this year. And as the year got a little bit more advanced, we saw what a heavy lift that was to be able to basically look at our rules and regs and if necessary, the statutes and say, hey, does this really resemble how we practice today? and what is the best way for consumers and for our members to really be practicing real estate. And the more we looked at it, we're like, wait a minute, this is really more of an ongoing issue, not a one-time issue. So we did put in place this standing committee now. And so that was one of the questions that came up here. Denise Foreman Gaines asked, how was the panel selected for the licensing and practice committee? And the panel was selected. I consulted with each of the 3 local presidents and asked them to give me 1 or 2 recommendations of people in their association, somebody that is very involved, that knows the rules and regs, that is in some type of a leadership role within their brokerage or their association, and that they understand the implications of the rules and regs and the agency statutes and all. So I did that. I chose those people based on their current contributions to the state and their local associations and their recommendations from their local presidents. Okay. Steve Crifalsi, you have probably the best question on here, not to minimize everyone else's, of course, but what's the plan to appeal the legislature to reduce the transfer tax back to 3%? Stay tuned for next year because that is an ongoing discussion. And then, Andy, I think there was one last question just to wrap it all up. So if you have any more questions, get them in super, super quick. But the last question came from Todd Stonecipher. And Todd, you are full of good questions today. Let me find it real quick. But Todd said, if there is buyer brokerage compensation offered, how would you advise the buyer agents that want to negotiate their commissions to do so? And I think you already gave a good guidance on that by providing that language in the agreement of sale.
So you say if there is buyer compensation offered?
If there is buyer brokerage compensation offered,
right,
how would you advise your buyer agents that want to negotiate their commission to do so?
Well, let's look at a couple different scenarios. Yeah. So the one I talked about a little before was that if the compensation offered to the buyer's agent did not meet the level of compensation that the buyer's agent charges, then you could use that kind of language that I mentioned to you to put in paragraph 32. Let's look at a little flip side of that. Interesting scenario. Suppose in the competitive marketplace, a buyer's agent has said, I charge this amount, and obviously talking about antitrust, we never use exact percentages or dollars or anything. So follow my hands here. So the buyer's agent has said, in my marketplace, I'm offering these services. Here's what I do. Here's my compensation. Suppose that buyer is making an offer on a property where the seller is offering this amount of compensation to the buyer's agent. What about that difference in between? So it could be that the buyer's agent, maybe their agreement says they would get paid that amount. Or the buyer's agency agreement could say that, that's what'll show, that's what'll be accepted through the negotiation process. But this difference would be done as a credit to the buyer. In Delaware, the Licensing Act, the rules and regulations say that a real estate licensee can pay something of value, can pay money, can pay compensation, can give them a home-baked apple pie, something of value to a client or customer. They cannot give something of value to, let's say you're at the beauty salon and you get a tip about somebody who may want to list a property. And if the person who gave you that tip is not a licensee, you cannot pay them compensation for that tip that way. But the compensation money, things of value can be shared with a client. So in that situation, and I don't know if Todd had that in mind as well as part of the question, but I kind of launched off into that. So I hope I answered the question
in like a 360 approach.
Okay, thank you.
Yeah, I think you did. I think you did good, really good. And that looks like all the questions that we had. So yeah. Thank you, everybody, for attending, for participating, for sending in your questions. And just a reminder, go ahead and scan that QR code to get all of Andy's docs. And absolutely, please reach out to your local associations. Your questions about Lockboxes, your questions about, access to properties through the lockbox system. Talk to your brokers and talk to your local associations about that, because there's contracts in place between Century Lock and each of the local associations. So thank you, everyone. Have a really great afternoon. And it was snowing here earlier. I'm not sure if it's snowing where you are, but hey, it's winter time now. So happy holidays.
Have a good day, everyone.